Voting trusts. Hello again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now let's turn to voting trusts. This is a different tool used for a different problem. An owner trust addresses who holds title to the aircraft. A voting trust addresses whether an entity can qualify as a U.S. citizen for registration purposes. The controlling definition is in 49 U.S.C. section 40102A15. For a corporation or association to qualify as a U.S. citizen, it must be organized under U.S. law. Its president and at least 2/3 of its board and other managing officers must be U.S. citizens. It must be under the actual control of U.S. citizens, and at least 75% of the voting interest must be owned or controlled by U.S. citizens. When those citizenship percentages are strained by foreign investment, a voting trust may be considered. But this is not a casual fix. It's one of the most scrutinized structures in the registration rules. Here, the key FAA regulation is 14 C.F.R. section 47.8. If a voting trust is being used to qualify the corporation, the applicant must submit a true copy of the fully executed voting trust agreement. That agreement must identify each voting interest and must bind the voting trustee, the applicant corporation, the foreign stockholders, and other parties to the transaction. The FAA also requires an affidavit from each voting trustee. Each trustee must represent that he or she is a U.S. citizen with statutory definition. It is not a past, present, or prospective director, officer, employee, attorney, or agent of another party to the trust agreement, is not a present or prospective beneficiary, creditor, debtor, supplier, or contractor of another party, and is not aware of any relationship that could influence the exercise of totally independent judgment. That is not window dressing. It is the FAA telling the market exactly what it fears: hidden influence dressed up as formal compliance. The phrase I would emphasize here is actual control, because actual control is where voting trust structures either stand or fall. The FAA will look past elegant drafting if the real-world arrangement allows foreign parties to call the shots. Who selected the trustee? Who can replace the trustee? Are there side letters? Are there veto rights? Are there financing covenants that effectively dictate governance outcomes? Does someone outside the voting trust still have the practical ability to force decisions? Those questions matter more than the rhetoric in the recitals of the documents. Another important point, the voting trust agreement must provide for succession of a voting trustee in the event of death, disability, resignation, loss of citizenship, or another replacement event. And the replacement trustee must immediately submit the required affidavit. A broken succession mechanism can become a broken citizenship analysis. Also, a voting trust must not empower a trustee to act by proxy. The FAA wants the trustee exercising independent judgment directly. From a corporate and transaction perspective, voting trusts can create second-order issues that should not be underestimated. They can affect shareholder expectations, government or governance dynamics, lender diligence, negotiated control protections, and sometimes tax planning. A structure that solves an FAA citizenship issue on paper may create a broad control or board control problem, a lender consent problem, or a dispute resolution problem somewhere else. So, The right question is not simply, can we build a voting trust? The right question is, can we build one that is compliant, financeable, governable, and durable? Periodic review is essential. If ownership shifts, if board composition changes, if side agreements are amended, or if a financing package introduces new control rights, citizenship compliance can erode without any obvious warning light on the panel. I'd like you to remember this. Take this away. With voting trusts, the FAA is not counting shares only. It is tracing control. When properly structured, voting trusts can reconcile foreign capital with U.S. registration requirements. When poorly structured, they invite scrutiny, delay, and potential loss of registration eligibility. The bottom line is simple. A voting trust is not a cosmetic solution. It is a precision instrument. And precision is exactly how it must be drafted, implemented, and maintained. Thank you for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Questions are certainly welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate these questions and issues with precision.